In a 1992 speech titled Democracy, Human Rights, and the Realities, the then Senior Minister of Singapore, Mr. Lee Kuan Yew, made this statement. With few exceptions, democracy has not brought good governance to new developing countries. What Asians value may not necessarily be what Americans or Europeans value. As an Asian of Chinese cultural background, my values are for a government which is honest, effective, and efficient. Mr. Lee Kuan Yew was always great at throwing shade. But jokes aside, this statement was very much in line with what is known as the Asian values debate. This was a debate championed by Mr. Lee Kuan Yew, as well as Dr. Mahathir Mohamad of Malaysia. The argument was that Asian countries were fundamentally different from Western countries. Within this rhetoric, human rights ideals like political freedoms, like freedom of speech, were deemed antithetical to certain communities and seen as a form of Western democratic imperialism. Such a view still exists today. Some of you might be aware of the 2014 Umbrella Movement in Hong Kong. This was a pro-democracy movement which saw tens of thousands of individuals take to the streets to protest for free and fair elections. As you can see from these pictures, it was not just an isolated group of individuals, but rather an entire community that stood up to protest for what they felt were their human rights. Mainland Chinese officials immediately responded to this by pointing their finger at the West. They argued that these pro-democracy advocates were being used as tools by Western forces, and some officials even alleged that the US government was behind these protests, citing its record for interference in other countries' internal affairs. Now, all of this sounds a little far-fetched and has been described as so by international and domestic media. But if you really stop to think about it, such a stance is not completely unreasonable. Because for countries like Hong Kong, like Singapore, like Malaysia, post-colonial countries, the notion of human rights has a very different meaning than it has for countries in the West. In fact, the colonial history of international law means that whenever these countries harness international systems and norms, they're participating in a conversation in which they have been traditionally disadvantaged. Now, some of you might be wondering why, right now, what colonial history? Well, you're in luck, because this actually brings me to the topic of my talk: critical faith, international law, human rights, and the third world. My name is Natalee Ho, and my concentration at Gallatin was law in the post-colony, where I looked at international law from a post-colonial context. I am from Singapore, so a lot of this actually has personal significance to me, but enough about that. The traditional historical narrative of public international law casts it as some sort of a bandage to the wounds of war and strife. It's seen as a manifestation of lessons learned from prior abuses of power, from prior mistakes. More importantly, it's seen as a series of doctrines and principles that emerged from Europe, that developed from the Peace of Westphalia, and thus developed independent of their interaction with non-European territories. Despite this, it's cast as ahistorical and universal, and thus applicable to the rest of the world. Conventional understanding of international law thus places colonialism and non-European peoples and their practices in general as peripheral to the discipline. However, an alternative reading of international legal history has been put forward by self-professed third world scholars. These scholars emphasize on the relationship between colonialism and international law, as well as the legacy that this relationship has engendered. So instead of on the periphery, colonialism is placed right at the center of the development of international law. Such an approach is termed third world approaches to international law. It's not just a school of thought, but also an intellectual and political movement. This means that the term third world is somewhat of a nom de guerre, an assumed name under which a group undertakes combat. By banding together under the label of third world, these lawyers and theorists hope to expand and challenge what was once a pejorative term, and also point towards a common history, that of colonialism. More generally, the term Third World refers to societies and territories that were colonized by the European Empire from the 16th century onwards. This is a diverse group of countries with many different aspirations, with different concerns, and different experiences. Therefore, contrary to popular conception, Third World doesn't refer to a particular economic situation, but rather it refers to shared history of colonialism. Of course, there are correlations, but really it's colonialism that binds all these countries together. So let's begin this story with the early colonial origins of international law. These two men are commonly seen as the fathers of international law. It's no coincidence that they're both from countries that were early colonizers. Today I'm actually going to talk a little bit more about Victoria. This is because Hugo Grotius is commonly seen as indebted to Victoria's ideas, and also because, unlike Grotius, Victoria is seen as somewhat of a humanitarian. He very famously said this: "The true state of the case is that they," referring to the natives, "are not of unsound mind, but have, according to their kind, the use of reason." This was very different from thinkers of that time because he actually characterized the natives as having the use of reason, as being human. However, because of this, because they were human, they were thus bound by universal natural law. In this case, the natives were deficient and unfit to administer a lawful state up to the standard required by human and civil claims. Victoria then suggests that proper government be established over the natives by the Spanish. And therefore, by simply having their own institutions, by having their own cultural practices, by just existing, the natives were in violation of this universal law and standard, which, of course, was derived from Spanish, or rather, European cultural norms. Therefore, Victoria humanized the natives and universalized Spanish and European norms. He also established the Spanish as agents of natural law. By doing this, he justified Spanish intervention because he characterized the natives as uncivilized and backward. Therefore, any intervention, regardless of how violent, was humanitarian and liberating. This also designated sovereignty as a privilege that only certain countries and certain cultures similar to the Spanish, could enjoy. The true violence of this is brought home by Victoria's argument that the Spanish should be allowed to travel freely through the land of the natives. Any resistance to Spanish penetration would amount to an act of war, and therefore justify Spanish retaliation. In this case, the Spanish can make war on the Indians, no longer as on innocent folk, but as against forsworn enemies, and may enforce against them all the rights of war. So much for humanitarianism. The humanity of the natives was used against in a 19th century wave of imperial expansion, where the natives were seen as legal entities only insofar as to transfer rights, property, and in certain cases, sovereignty. This mural depicts Sir Stamford Raffles signing an agreement with the native Sultan of Johor, Tengku Hussein, in 1819. This treaty effectively enabled the British East India Company to set up a trading post in Singapore. However, subsequent agreements to divvy up the land did not involve Tengku Hussein, and in fact only involved the Dutch colonial power at the time, as well as the British. Therefore, it was never just a matter of simple exclusion, but also a matter of inclusion into systems where the rules were set against the Third World. This claim to universality had a double-sidedness that eventually came to work against colonized peoples. Now, presumably, these imperial practices should have ended with decolonization, and the formation of the UN was extremely useful to the anti-colonial movement. Anti-colonial leaders and social movements of indigenous rights used the language of human rights and self-determination to challenge their oppression. The UN lent an aura of legitimacy to the anti-colonial, anti-apartheid movements, and also helped confirm the legality of Third World claims to sovereignty. However, even as rights discourse was being used for anti-imperial purposes, it also took on a new role in the expansion of Western imperialism. The protection of rights, became doublespeak for Western economic, political, and even military intervention. As such, the Vietnam War was a pro-democratic one, as was the US invasion of Panama and the Iraq War. Now, if you look at the tactics that these Western occupying forces used in these recent interventions, you might find it sort of familiar. First, there came a proclamation of the universality of human rights, with attendant discourses, attendant axioms, actually, of good governance, democracy, and development. Then came the justification of intervention because of the country's perceived failure to achieve these axioms. And lastly, all this designated sovereignty as the domain of the free and democratic West alone. Sovereignty, once again, was turned on its head and used against the Third World. As you can see from this, the structures of oppression have persisted to present day. Now, even if we were to move beyond something as extreme as military intervention, economic imperialism remains a lived reality for many Third World countries. The exploitation of the Third World has been supported by international legal systems through schemes like the Structural Adjustment Program, as well as various foreign investor protections. This, of course, has been done with the complicity of certain citizens of these Third World countries. Colonialism has been replaced by neocolonialism, and this puts Third World countries that do not provide favorable economic conditions for First World countries, as well as countries whose total exploitation and destruction will provide maximum benefit for Western countries, in a state of economic disadvantage. So what now? What does all of this mean for people who live in Third World countries? What does this mean for someone like me? Because in light of all that I've told you, it seems like the Chinese officials were right about the umbrella movement. And what they said, their reasoning was pretty much reasonable, as well as a well-intentioned resistance to Western hegemony. I beg to differ, because firstly, I believe that justice is not a Western concept. The content of human rights is not a Western concept. In fact, many scholars, such as Amartya Sen and Christopher Weeramantree, have located human rights ideals such as the equality of all human beings and the illegality of hyper-destructive weapons in Buddhism and Hinduism. Moreover, Western cultures have displayed repressive tendencies just as Third World cultures have displayed liberal ones. Cultures evolve and are extremely complex. To assume a static point of origin, whether Western, Asian, or African, is not only arbitrary, but completely unfounded. Not only that, the concerns of human rights proponents in Third World countries are categorically domestic. This is best articulated in this quote by Aung San Suu Kyi. Those who wish to deny us certain political rights try to convince us that these are not Asian values. In our struggle for democracy and human rights, we would like greater support from our fellow Asians. Inequality, suffering, and oppression, these are facts in Third World countries. These are facts in all countries. And some local governments have proven themselves as capable of inflicting brutalities as their former colonial masters. The account of history that I've pursued throughout my entire presentation has been used to support and justify repressive and authoritarian regimes. However, resistance to these regimes, articulated in domestic terms, is clear indication that freedom is not something that belongs solely to the West. However, the reservations of Third World scholars regarding the imperialistic potential of human rights discourse, as well as the international legal system, is valid. Therefore, we should not only ask to be heard, but also question the assumptions within our conversation itself. It is here that I suggest the maintenance of a critical faith. This is a term borrowed from the modern legal scholar Sundya Poja. What it means is to maintain a strong faith in international law while still comprehending its complicities with powerful actors past and present, as well as its limitations. It means understanding that justice is not guaranteed by the international legal system, that unjust outcomes are not necessarily distortions of law, but sometimes the exact and intended results of law. However, it also recognizes the anti-imperialistic potential of international law and human rights discourse. The erasure of inequality is a huge problem in international law because it claims to be ahistorical and universal. However, it's precisely because of this universality that allows social movements to make claims through it. In fact, international legal systems and international law have been successfully used to redress injustices. What we have to do as agents of change is to press our understandings into an unsatisfactory status quo. And at the same time, we also have to understand that people with opposing motivations, opposing goals, can and will do the exact same thing. Nothing is sacred. There is no ideology, no moral code, no system, and no law that will guarantee you a just outcome. This doesn't have to be scary at all. Actually, I think it's kind of great. Because what it means is that the inequalities and injustices that we see in our world today are not inevitable. And we have the power to question the givens. This applies to everything, not just human rights issues in post-colonial countries, but also civil rights issues in America, and also global gender rights. So in the words of the amazing transgender rights activist Jeanette Mock, let's not be basic, people. As we reject the transcendence and unassailability of human rights doctrines, we open ourselves up to a praxis that is truly counter-hegemonic, that is rooted in compassion and empathy. Instead of focusing on ideals, we should be focusing on the express needs of the people that we're trying to help, on the most marginalized members of our community. It is in this way that I believe justice can truly be achieved. Thank you.